सर आज एल
Sir,
विक्टोरिया
the court has received petitions challenging the appointment
सुनवाई की। कोर्ट ने ये कहा कि हम इस याचिका पर कोई आदेश जारी नहीं करेंगे। उनके शपथ लेने को चुनौती दी गई थी, उनकी आइडियोलॉजी को भी चुनौती दी गई थी और ये कहा गया था कि इस पर दोबारा विचार किया जाए। बार काउंसिल की तरफ से ये भी कहा गया कि इस पूरे मामले में कोई शिकायत अभी तक दर्ज नहीं कराई गई। इस पूरे फैसले को कैसे देखते हैं और क्या ये एक बड़ी साजिश है न्यायपालिका को लेकर?
So what is the impact of something like this on the judiciary and in the bar?
See, whatever the court has done, the order passed by the court is perfectly all right. Actually, this should have been the decision of the court. Otherwise, it would have created a very wrong precedent. जो भी कोर्ट ने किया है बहुत अच्छा किया है और मुझे लगता है कि इससे बढ़िया डिसीजन नहीं हो सकता था। अदरवाइज एक बहुत ही गलत प्रेसिडेंट काम हो जाता। कोर्ट ने ये कहा है कि देयर आर टू फैक्टर्स टू बी कंसीडर्ड बाय द कॉलेजियम। वन इज एलिजिबिलिटी, अनदर इज सुटेबिलिटी। Both the factors, the collegium of the High Court, the collegium of the Supreme Court, they consider very well. दोनों फैक्टर्स को एलिजिबिलिटी आप उस संविधान के तहत आप एलिजिबल हैं नहीं हैं, सुटेबल हैं कि नहीं कि आप जज के पद को आप बरकरार रखें। तो ऐसी स्थिति में कॉलेजियम, द गवर्नमेंट, द स्टेट गवर्नमेंट, द सेंट्रल गवर्नमेंट, द आईबी, so many agencies, so many authorities, they consider the suitability and the eligibility. And when they find it that any lawyer or any person of subordinate judiciary is perfect to be a judge of the High Court or Supreme Court, then these cannot be now examined by the judicial side. Then therefore, whatever the court, and we also submitted that there is absolutely no complaint against her with regard to any misconduct, other misconduct or professional misconduct throughout her career. Therefore, the court should not interfere, and the court did.
So when we see this kind of cases coming up, particularly since the questions were being asked about this speeches she had made or articles she had written, how do you see this entire development?
See, you know, if my name is recommended by a collegium, any collegium, then the complaints, so many letters, they reach to the collegiums and the government. And many facts which even I don't know about me, those are disclosed. Therefore, it is beyond presumption that these materials, these hate speech or whatever materials they were alleging today, they were not before the collegium.
So the bench has also said that
these are the matters of the year 2018. Now, you know, the court also gave the example of so many judges.
So the bench has also
Justice
said
Krishna
that
Iyer's.
there is no problem in judges having a political affiliation before they become.
Naturally, the past has shown it. Justice Krishna Iyer was one of the best judges of the world. Therefore, and so many others, even sitting judges are there who had political connections. But nowadays,
Justice Gowri mentioned his own political affiliation.
उन्होंने कहा कि जज बनने के पहले मैं भी किसी पॉलिटिकल पार्टी का मेंबर था, लेकिन 20 बरस में जब से मैं जज हूँ आज तक तो ऐसा कुछ नहीं लगा। और सारा बाहर जानता है, सारी दुनिया जानती है कि पहले आप क्या रहे हैं, बाहर में आप क्या रहे हैं उसमें, और द मोमेंट यू होल्ड दैट चेयर ऑफ ए जज, जब द व्यू चेंजेस, यू बिकम इम्पार्शियल। ये ऐसा होता रहा होगा।
सर, तो क्या आप किस तरह से देखते हैं?
न्यायपालिका पर दबाव डालने की कोशिश की गई इस पूरे मामले में?
हाँ, अवश्य इस ढंग के रिट पिटिशंस कोर्ट ने सही किया कि इन लिमने इसको डिसमिस किया। इस ढंग का दबाव नहीं होना चाहिए। आप उम्मीद कर सकते हैं वारंट अपॉइंटमेंट इशू हो गया और उसके बाद अब है कि अब सुबह में एक माइक नीचे कर दो माइक, पता नहीं क्या होगा।
Council of India.
पे कि पता नहीं क्या होगा, उस ऑनरेबल जज या उस लॉयर पे क्या बीतती होगी। तो ये दबाव डालने का ये है क्या?
Sir, yesterday the Chief Justice in open court observed that there are some issues that had come before the collegium after the recommendation was sent. So do you think the Chief Justice should not have made that kind of a comment or listed the matter?
Honorable Chief Justice, at the time of mentioning, the file was not before him. The collegium proceedings were not before him. Whatever the mentioning lawyer he submitted, the comment came because of that only. The records were not before him. And really so many meetings are being held, so many recommendations are made. Therefore, to remember each and every lawyer whose name has been recommended, it is not possible.
Sir, you have been observing the court since long. What do you think, whose failure is this, that these facts were not known, if at all?
No, it is not a failure on the part of anybody, neither on the part of the government nor on the part of the collegium. Everything, the collegium would not have found it suitable or sufficient ground for rejecting her name. Therefore, it is not a failure at all.
The collegium would have looked into all of these issues already.
Certainly. It cannot be presumed that these materials were not before the collegium.
All right, so that's the Bar Council chairman, Manan Kumar Mishra, who said that he had checked with Bar Councils. There have been absolutely no complaints of misconduct against the person. All the necessary protocols were followed while the appointment was done, and this petition was completely unnecessary and also welcoming the order.